Introduction, Section 1, Part 3. The incident, I mean, was the fixing the Court of Common Pleas, the grand tribunal for disputes of property, to be held in one certain spot, that the seat of ordinary justice might be permanent and notorious to all the nation. Formerly that, in conjunction with all the other superior courts, was held before the King's capital justiciary of England in the Aula Regis, or such of his palaces wherein his royal person resided, and removed with his household from one end of the kingdom to the other. This was found to occasion great inconvenience to the suitors, to remedy which it was made an article of the Great Charter of Liberties, both that of King John and King Henry III, that common pleas should no longer follow the King's court, but be held in some certain place, in consequence of which they have ever since been held, a few necessary removals in times of the plague excepted, in the Palace of Westminster only. This brought together the professors of the municipal law, who before were dispersed about the kingdom, and formed them into an aggregate body, whereby a society was established of persons who, as Spellman observes, addicting themselves wholly to the study of the laws of the land, and no longer considering it as a mere subordinate science for the amusement of leisure hours, soon raised those laws to that pitch of perfection which they suddenly attained under the auspices of our English Justinian, King Edward I. In consequence of this lucky assemblage, they naturally fell into a kind of collegiate order, and, being excluded from Oxford and Cambridge, found it necessary to establish a new university of their own. This they did by purchasing at various times certain houses, now called the Inns of Court and of Chancery, between the city of Westminster, the place of holding the King's courts, and the city of London, for advantage of ready access to the one, and plenty of provisions in the other. Here exercises were performed, lectures read, and degrees were at length conferred in the common law, as at other universities in the canon and civil. The degrees were those of barristers, first styled apprentices from apprender to learn, who answered to our bachelors, as the state and degree of a sergeant, servientis ad legem, did to that of doctor. The Crown seems to have soon taken under its protection this infant seminary of common law, and the more effectually to foster and cherish it, King Henry III in the 19th year of his reign issued out an order directed to the mayor and sheriffs of London, commanding that no regent of any law schools within that city should for the future teach law therein. The word law, or leges, being a general term, may create some doubt at this distance of time whether the teaching of the civil law, or the common, or both, is hereby restrained. But in either case it tends to the same end. If the civil law only is prohibited, which is Mr. Selden's opinion, it is then a retaliation upon the clergy who had excluded the common law from their seats of learning. If the municipal law be also included in the restriction, as Sir Edward Coke understands it, and which the words seem to import, then the intention is evidently this: by preventing private teachers within the walls of the city to collect all the common lawyers into the one public university which was newly instituted in the suburbs. In this juridical university, for such it is insisted to have been by Fortescue and Sir Edward Coke, there are two sorts of collegiate houses, one called Inns of Chancery, in which the younger students of the law were usually placed, learning and studying, says Fortescue, the originals and, as it were, the elements of the law, who, profiting therein as they grow to ripeness, so are they admitted into the greater inns of the same study, called the Inns of Court. And in these inns of both kinds, he goes on to tell us, the knights and barons, with other grandees and noblemen of the realm, did use to place their children, though they did not desire to have them thoroughly learned in the law, or to get their living by its practice, and that in his time there were about 2,000 students at these several inns, all of whom, he informs us, were filii nobilium, or gentlemen born. Hence it is evident that, though under the influence of the monks our universities neglected this study yet, in the time of Henry VI it was thought highly necessary, and was the universal practice, for the young nobility and gentry to be instructed in the originals and elements of the laws. But by degrees this custom has fallen into disuse, so that in the reign of Queen Elizabeth Sir Edward Coke does not reckon above 1,000 students, and the number at present is very considerably less, which seems principally owing to these reasons. First, because the Inns of Chancery, being now almost totally filled by the inferior branch of the profession, they are neither commodious nor proper for the resort of gentlemen of any rank or figure, so that there are now very rarely any young students entered at the Inns of Chancery. Secondly, because in the Inns of Court all sorts of regimen and academical superintendents, either with regard to morals or studies, are found impracticable, and therefore entirely neglected. Lastly, because persons of birth and fortune, after having finished their usual courses at the universities, have seldom leisure or resolution sufficient to enter upon a new scheme of study at a new place of instruction. Wherefore few gentlemen now resort to the Inns of Court, but such for whom the knowledge of practice is absolutely necessary, such, I mean, as are intended for the profession. The rest of our gentry, not to say our nobility also, having usually retired to their estates, or visited foreign kingdoms, or entered upon public life without any instruction in the laws of the land, and indeed with hardly any opportunity of gaining instruction, unless it can be afforded them in these seats of learning.